The only thing we have to fear is fear itself.
Justice requires us to remember when any citizen denies his fellow, saying his color is not mine, or his beliefs are strange and different. In that moment, he betrays America.
Be nice, patient, and continue to pray. In 100 or 200 years, the problem will work itself out.
I believe that truth is the glue that holds government together. Not only our government, but civilization itself.
In this present crisis, government is not the solution to our problem. Government is the problem.
This nation was founded by men of many nations and backgrounds. It was founded on the principle that all men are created equal, and that the rights of every man are diminished when the rights of one man are threatened.
America is never wholly herself unless she is engaged in high moral principle. We as a people have such a purpose today. It is to make kinder the face of the nation and gentler the face of the world.
There is nothing wrong with America that cannot be cured by what is right with America.
Through much of the last century, America's faith in freedom and democracy was a rock in a raging sea.
Starting today, we must pick ourselves up, dust ourselves off, and begin again the work of remaking America.
Hello, hello, hello. Welcome to True Crime and Legal Updates, the normal spot, Tuesdays, 7 o'clock. And tonight, after greeting all of you in the chat and whoever may be watching out there on YouTube or Twitter or now or later, tomorrow, whenever, hope everybody's having a good day, whatever day of the week it is for you, whatever time of the day it is for you. Nice to see some of you in the chat from yesterday when we did the legal cases that are on deck for Donald J. Trump. And yesterday we covered the ones that were in New York. We covered the two trials that have gone to verdict already, gone to the jury, and come back with penalties and fines and fees that need to be paid by Donald J. Trump in the E. Jean Carroll in the New York civil fraud case that was brought forward by Letitia James. And we covered D.A. Bragg's upcoming criminal trial for election interference in mishandling of documents, mishandling of the reporting of funds like a business fraud, criminal charges brought up by D.A. Braggs from Manhattan against Donald J. Trump in regards to the hush money payment that they're calling it. They call it the hush money case in regards to money paid to Stormy Daniels not to release her story prior to an election. Yada, 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 yada. We covered all of that. But just a brief update because more happened yesterday. Right while I was streaming, or I started to see articles being posted that Judge Juan Merchan, who is the judge in the New York hush money case, had clarified his gag order. He had not listed the families of himself, the judge, and or prosecution's team, or any other family members related to people in regards to trust. But he did amend it to include it. He also clarified that since it wasn't there, that what Trump had tweeted prior was not technically in violation of that gag order because he had not listed his daughter or his family members or D.A. Bragg's family members specifically. But now it's all inclusive of family members of anyone involved with the case. It is very clear he put that through. Okay. And also, I read an article that Trump's team has put on notice that they will redo their motion to have Judge Merchan recused. They want him to recuse himself. They want him removed. based on this relationship with his daughter, based on his daughter's politics. That motion was denied prior. But here's the other thing. Now they've got a motion. They're putting together a motion. I don't know if they've actually filed it yet, but I read an article that stated they gave notice that they will be filing to move the trial date because of all the publicity it's getting. And I know that that probably came out a little snarky, but in all honesty, it is rather snarky. That it just made me tilt my head to realize that the team in the defendant that is drumming up most of the publicity in regards to this case is saying there's too much publicity in regard to this case. The man who is tweeting 17, 18, 19, 70 times a day. That might be an exaggeration, 70. Don't hold me to it. But yeah. Mm-hmm. Mm-hmm. I just yeah. Mm-hmm. Question from Mark. Do you think an amendment like that will become a commonly used thing, set a precedent? I think that in the gag orders they may be clearer. Okay. I think that noticing how he's gone from trial to trial in the publicity that's put out, I think that Donald Trump has set a pretty good pattern on how he's going to react and how he goes after anyone involved in the trial. It's just his style. That's the kind of competitor businessman that he was. That's how he rules everything. um with ferocious attacks like that, nothing has to be true. They just say what they want. They just put it all out there, um stirring it all up. Judge Juan Merchan doesn't seem to be playing the same game. He's being very strict in his. I did list the amendment to the gag order below, and I would recommend everyone read it. It's not very long, but it shows that it shows what Judge Merchan was focusing on. He's trying to be as balanced as he can, but he has to weigh the safety of everybody involved and also the system in itself. Intimidating people to be part of the process is a problem. No one's going to want to be a part of a process that's going to cause you a whole bunch of grief. It puts your names, your family, what you ate for dinner, who you dated 20 years ago out in public view. I mean, people just don't operate like that on a regular basis. This is clearly intimidation and harassment of anybody involved in the case. Any leverage that they can use, to do it. And I'm hoping that more judges will be more specific about it. When you read the statutes that he put down there, and actually the references that he did, and he's clearly trying to protect the constitutional right for Donald Trump to speak freely about certain things, and he can campaign as Judge Merchan said in his order. It's not about that. It's about the protection of the process and the integrity of the process, and that that is not normal campaign speech to just go out on everybody who's involved in a criminal trial against you. I mean, if he wants to talk about the judge and or the prosecutor and say that his charges, that he's innocent, that these charges are trumped up, just like any other defendant, that would be fine. Because let's be honest, most cases don't have to have gag orders to this extent on how to speak or where to speak or who to speak about. Okay. They don't. I mean, common sense would say you just don't talk about the case. That would be prudent. However, that's not what's going on. And now we shall see if this whole undue publicity that's been going, because this is what they want. They want to cause all the problems, then point the fingers at everybody else caused the problem. I mean, to actually say that undue publicity has been caused by the judge in the DA to make him look in a bad light. So the trial should be moved more into the future to keep him from looking in a bad light. I would say that that's not exactly a good way to represent what's going on here, because in that essence we should have the trial sooner, because he's going to keep talking and he's going to keep making publicity. And when I say he, I do mean the defendant himself, Donald J. Trump. He's going to keep grandstanding. He's going to keep talking about everything and twisting. And he and his lawyers are the ones out there doing the tour. Okay, they are the ones out there speaking on it regularly. And so then to just pull this, oh, it's about the pretrial publicity, like it's just not fair. It's prejudicial against my client, and now we can't really go forward with a trial on April 15th because it's just too soon in this environment. Which hashtag they created themselves. Yeah, I just just blew my mind. Got a good chuckle over that read this morning, actually. A chuckle in the absurdity of it. It's the absurdity of it. But we'll see where it goes. I mean, motions are motions. Legal argument and precedents. Trump's team is not known for putting a lot of legal argument in there. They just like to paint scenarios, as the judge said, and not back it up with any legal precedent or anything that he should be looking at. So for when he says that these comments and this rhetoric is farcical, he's pretty correct. Pretty correct. Okay, so hello everyone in chat. Welcome, Liam. Hi, Christopher. How are you? It's good to see everybody. Hey, Suzanne. Suzanne says, "Did you see all the crazy Easter morning tweeting that Trump did?" I did, but I don't pay attention to that campaign stuff like too much. I did see that he was selling a special Bible for his campaign and stuff, and there was a lot going on. But to say that I followed the tweets and all, pretty much not, unless it gets into a really big article from a big news organization. I'm not really paying attention to it. The attacks on the system itself, when they're coming to light in emotions, like I'm following like all of that. A couple of lawyers I watched said that the staggering approach to Trump's escalation is done to ensure a lack of evidence for retrial based on bias. Is that, that's interesting. I don't know where to go with that one, Liam. That's a good thought there. Hello, Commander. Oh yeah, it lets it create a toxic environment and then complain about the environment being toxic. Exactly. Hello, Sean. Exactly. Hey, Darth. At the appellate level. You know what? They win and they don't. Remember, presidential immunity was struck down at the appellate level all the way up to the Supreme Court in the civil cases. He was not acting with immunity. We have to wait. Remember, we are still waiting for the presidential immunity part up there in the Supreme Court. April 22nd, I believe they will be hearing about that. The appellate court is not I don't know about winning. They did overturn Eileen Cannon in the beginning. Yes, they did. They did strike a few things out, and they have, I don't know, like winning, yes, as far as getting a stay and a reduced fine, that's definitely a win. But I don't know how many like wins really at the appellate level like there have been. Remember, it was false reporting that the Trump campaign said that the whole cases were dismissed at the appellate level just because one or two parts got struck down, to be reclarified and refiled, by the way, not struck like completely. Same thing happened in the Georgia case. Judge McAfee recently has taken a few of those counts out and said that they did not allow for jurisprudence. They weren't prudent and listed enough to where the defense could defend themselves against it. There wasn't enough there. The actual scenario that happened was documented well. However, it did need to be tidied up because it wasn't actually, there wasn't enough there to defend against, because they were talking about constitutional issues that were so broad, there was no way to figure out what they were actually defending against, basically. But now we're getting into the cases, so I'm going to start, let's just start with the cases like that. But it was a good question, Darth, because a lot of people do believe there's a lot of winning going on in the Supreme Court level, and there's even been a lot of pushback on some of the judges, especially Eileen Cannon, about not actually putting her rulings in writing anymore. She's only doing everything, holding everything back. currently. She's being real careful. In like I said yesterday, it's because there's such a spotlight on the judges and everything that they're doing. But the judges' rulings are not actually getting pulled back. So there's not that going on. Uh, all of the gag orders have actually stood based on appeal all the way up. So it depends on exactly what area you're talking about. Mm. Yeah, well, I would say on all levels, there's always is, I mean, that's a pretty broad statement. Dark to say it's corrupt on all levels. I would say there is corruption throughout the system here and there, but I still really hold that the majority of it isn't. But then again, that's a whole different conversation that I'm not going to have about the trials. The trials. What I want to do is put out the trial information and not actually talk about like the the climate and the beliefs of many that this the whole system is corrupt, so Trump should walk free, because I really don't think he's above being questioned for the antics that he did. And I don't think anyone is above the law, any of them on any sides ever. And I just see a lot of favoritism back and forth on all sides going here. Everybody bending over backwards, not to be especially hard or to do things out of turn to a particular defendant, to where they're actually benefiting because people are being so careful. They're actually benefiting because people won't take the extra step. Now, in the case in Engeron's case, Judge Engeron had actually fined lawyers in Trump several times in violation of the gag orders that were done. No one has actually put him in contempt of court or locked him up, but there has been fines in at least that. The gag orders have stayed the time. And Judge Check-in in the January 6th, in the what they call the insurrection case and election interference case through DC, did not get overturned, has not been overturned in any of the proceedings, except for the fact the only thing that they allowed is for it to go up to the Supreme Court level, which is appropriate whenever there's an appeal or a question of law that way. That's not getting like overturned. That none of that has happened. Yeah. Hey Beck, how are you? Hey Sleep, nice to see you. Been a while. Okay, let's get to the presentation because I want to get the information out there before like opinion takes over the stream. Which can happen because whenever I talk about these stuff, it definitely it happens, nobody's fault. It's a contentious thing. Well, let's talk about the documents file out of Florida first. That's the first one I have up. I'm going to kind of, because there's 3 left to do, and I want to try to finish them for part 2. I really don't want to do a part 3 of this. Okay. So this criminal case started back in June 2023 when they unsealed the indictment. It was revised in July. Jack Smith was appointed as the special counsel in this case and brought forward the trial. It was like, it's not that, you know what, Dart? It's not. This isn't a time or place to bring up conversations that you want to have. This is a discussion I wanted to have in regards to the 3 cases. Still, I had a plan yesterday. Well, I'm not going to get derailed, and I'm sorry that you look at it that way. I'm not trying to do that. But you always say that whenever it's something that you want to bring in and derail, you say that I just don't want to talk about it. Why don't you set up a time and place that we could talk about it officially instead of just coming in here and trying to derail something? Then I would do it. But I find it offensive when you do this. I really do. Because I'm not trying to silence you, but I am trying to do what I set out to do for today's stream. That's what's important for me today. Okay, you want to have a stream that you want to talk about that stuff, let's do it. I'm not against it at all. And I think you putting it out there that I am is bullshit. And that's why I'm saying this, because that's not true. Okay, so here we go. In the Mar-a-Lago case, and I apologize. Yeah, Christopher, you're welcome. I will actually hold a stream if anybody wants to talk about that whatever this is about the whole system being corrupt and everything getting appealed because all of these charges are there is law here. that was broken, and it can be addressed, and I just don't see that. But anyway, on this stream, let's get back to the fact. Jack Smith was appointed as a special counsel, and he brought two cases. One of them is the Mar-a-Lago documents case. That is what it's called in the media, Mar-a-Lago documents case. It's the United States government versus Trump. It is not one political party. It is the United States government versus Trump. And there was a long process to get to this place. Okay. The attorney of record for defense team for Donald Trump was Todd Blanche. Okay. And there was a tentative trial date set in the beginning for May 20th of 2024. And I can't actually say that that's actually going to come forward, because although there's not a lot of forward movement on the case, there are a lot of motions that have to be signed, and there's a lot of delays going back and forth. Although Eileen Cannon has actually asked about jury instruction at this date, which does look as if there's a little bit of movement. But anyway, the case itself involves 32 felony counts of willful retention of national defense information in violation of the Espionage Act, 6 felony counts of obstruction-related crimes under 18 U.S.C. 1512 and 18 U.S.C. 1519, 2 felony counts of false statements. Okay. There was scheduled hearing to confirm the trial date. That was March 1st, and they didn't mention it. Security of document evidence, orders not written unless appealed. This is all coming from the articles and the legal channels that I've been watching that keep bringing up the fact that Eileen Cannon, Judge Cannon, has stopped actually issuing out orders or handling motions in Lehman or any of that. She's waiting on this April 26th. We're all waiting on whether or not, because this actually happened when he was coming out, when he left office, during office, and when he left office, on presidential immunity and all of this, because that is the motion that was before the court for defense of most of these acts, is that the president can do what he likes, when he likes, regardless of law. Okay, we've talked about this case before. President Trump's team, based on the first campaign and the let's just call it the Hillary Clinton email issue, which was a big fiasco about emails getting dumped and this and that, and things missing. And it was of concern, such a concern that the Trump cabinet actually wrote new laws in regards to how security documents need to be handled, and actually clarified the whole process and what should happen, which is being used against Donald Trump because he actually didn't follow any of that process. Okay. And it's not uncommon that people have records that need to be returned. We saw that with Mike Pence, Joe Biden, in those recent investigations. They would say that that's actually of a clearance, that you shouldn't have that anymore. Like, it needs to be returned. It needs to go to the presidential archives, et cetera, et cetera. We have access to all these documents to do their jobs. The people in the cabinet at certain levels with security clearances, all the way up to the presidency. And of course, he has to see things and use things and have things, with him and brought to him that he needs to take care of. And that's not the issue. The issue is when approached. The reason the filing happened is because, let's be clear. When approached about the list of documents, there was denials, there was a partial return, there were signed affidavits from lawyers that everything was returned, and then there was a huge, and we're not talking a file box full of documents. We're not talking a briefcase that got misplaced or a couple of files here. We're talking a major amount of boxes of documents, and we're talking about the major issue that the government seems to be most concerned is not, number one, denying the whole process that they put in place in the first place, that they shored up in the first place, saying that they're immune from the process in the first place. Lying under oath was a big thing. That is a big thing. Saying they don't have any of the documents, and then receiving actually information from their own internal cameras and staff of boxes and boxes and boxes of them on a stage in the hall, the actual event hall of Mar-a-Lago, which multiple affidavits had said everyone could see the the boxes. Now nobody went up and they don't have pictures of people going into boxes and looking at them or stuff like that. But that is what they're saying was not exactly securing the documents in a safe way and putting information at risk that should not be out there. Okay, when confronted to bring these items back, there was claims that they did not have them, and then they have we've seen the videos of them moving the boxes on and off the plane. We know that there are other co-defendants that actually worked in the process with to actually delete video evidence of anything, delete actually any evidence that the documents were there. Why do that if you are going to claim that you had every right to have those documents? So it's like a double-edged sword. If you're innocent because you say that you can have those documents because you were the president, and that you have every right to say, okay, I lowered their clearance and they're not, like, I can have them, they're now mine. Not exactly how the process works. You don't just get to do that. There is actually a process to do that. He is correct. He could have done that, but he didn't. Okay, there's no documentation that he did it, but there's plenty of documentation that they went and hid the others. And it needs to come to trial because there's two sides to every story, and this is why there should be a trial on this. This is against procedures. He himself shored up thinking that he was going to snail every Democrat out there, I guess. I don't know. Or every person who has done anything like this. And it was based on the concerns from the campaign about people destroying emails and evidence that were used during the course of their service to our country when Hillary was, an ambassador, or when she was actually served in committees, or it's serious. She was running on a campaign, and he was saying that she shouldn't be trusted, and he changed the rules. And now those same rules, not even changed the rules, they just kind of firmed up the process. They didn't really make any broad changes to how anything was done. They just clarified it and put out a memo. I put that out in the first time that I talked about this case many months ago. And that happened through Trump's presidency. And now we have this case because they didn't even follow their own regulations. Okay. This case is considered very serious because, we're protecting our nation's secrets. And I don't know why people are not more focused on that part. Okay. This is not about persecution of one person. Okay. This is about the security of our country and our policies that are in place to protect us in the changing of hands of government officials. Okay. Keeping those secrets is the greatest responsibility of any of the public officials of these kinds of high rank with these clearance classifications. Those documents were definitely put at risk based on the things that have been put out there, like where they were located. There's pictures of them being in a bathroom. There's pictures of them being in the plant, shuffled around. But he also refused to comply with the subpoena. He tried to hide the documents, and he lied to the government through his attorneys, through signed statements that everything had been returned. These are all valid issues. No one's denying that attorney sent in a false statement based on Trump saying that everything was checked. Okay. Because she admits that she did. He said they had no documents and everything's been checked. And so that was what they submitted. Okay. Judge Cannon recently had ruled against Trump. No matter what the heat that they say that she's being unfair, she actually did do a ruling against Trump in regards to these documents because of how serious it is. She denied them access to the secret Section 4 filing, which is a filing that special counsel prosecution Jack Smith did in regards to protecting this information and why it's redacted and the reasons for the redaction. Even the reason they redacted it has to be actually sealed because of the security level of these certain documents. And it's not all the documents. I mean, a lot of it they were able to look at. Okay, but there's certain things that defendants are not allowed to have in these type of filings, and it's especially under the Classifications Information Procedures Act, which is CIPA. Okay, it's been long treated as inaccessible to the defendants themselves, because it discusses the very classified information that prosecutors want to redact, not made to the public, because it is dangerous Remember, in court proceedings, things get public. And the reason SEPA exists in Motion 4, actually Section 4 exists, is because they don't want this stuff to become public in trials like this, that there needed to be an exception to certain things and certain information, you know? Mm. Do you know whether the attorney intentionally lied about the documents or was reporting lies told by Trump? In her statement, that attorney said that she had questioned Trump about the documents and the subpoena. They were dealing with it in a client attorney, a manner, and that he said that the facilities had been searched, that he checked into it, and that he did do the return, and that all documents had been returned under that was all of them. But it was a portion of them. So a portion of them did get returned. When they say we returned the documents, that is in some ways true. But it's not all the truth. They did return some, but not everything that was on this list or that they were looking for. And so much more was found when they did the search later on Mar-a-Lago and found them all. And that was, they had to get permission to do that. And it was based on information coming from inside Mar-a-Lago itself. They could actually see the evidence through video and through testimony that people had seen these things and they had not been returned. And they had seen them after the submission was set that everything had been returned when they picked them up. Okay, because it was a year and a half of back and forth with the government and Trump about this before any of this happened. And all of that year and a half has been looked into by the special counsel to see if charges should come forward. Was it just that he was ill-informed? Was it just like they missed something? I mean, they had to check everything out well ahead before they brought these charges. They didn't bring these charges just because they thought there were more documents and he had lied on that statement. They had tried for a year and a half going back and forth. And then later, special counsel Jack Smith had to go back through all of that, all of the transactions between the government, Trump's attorneys and officials and people, all of the statements and everything before these charges were brought forth. And people seem to like miss that part of it, that this didn't happen like overnight. Okay, I don't think special prosecutors look at both sides of it all the way through to see if there is actually a governmental issue there that needs to be addressed. Okay, and so they have to do a thorough investigation forward before they bring the charges, and he brought them because he did feel that it was intentional that they kept those documents. Okay. In legal circles, they're talking about this being like, as far as the legal cases go, this one being with the most evidence to it's what happened. It's all very well documented, very public. Trump's not denying that letter went out from his attorney. He's not denying that the documents were at Mar-a-Lago. He can't, and he's not. Okay. The facts and legal theory are stated as pretty straightforward. There is written by his own cabinet how to handle these kinds of documentation, and they just need to prove that that's not what happened. Special Prosecutor Smith did, however, this is other legal channels' opinions. Like I actually have a slightly different opinion about the judge in this case than a lot of people do. I hear a lot of rhetoric against her. I actually am feeling kind of sympathetic towards the position that she's in under the microscope that she is, especially with this case. Whatever party she may be aligned to shouldn't have anything to do with her decisions, but she's getting a lot of pressure from all sides and from everywhere. She's already been returned. No judge wants to be overturned by their peers. No. Like, that's not why she's a judge, right? Like she wants to weigh things out and use solid law, right? And make your decision. No one wants to be overturned if you're a judge. To be overturned by your own peers is not a good thing. Okay. So everybody's got a spotlight on her. Publicly, a lot of the legal channels and some of the political commentators have said that, Prosecutor Smith got the short straw when he was randomly assigned canon because she was a Trump appointee. That's not, regardless of who appoints you, does not label you for life on how you're going to view these cases. And when a matter of law comes up to you, I doubt each judge is looking at it as a Republican or a Democratic. I do believe they are looking at it as a judge with all the legal knowledge that they have behind them and the history they have, their love of law and doing the right thing. I do. I mean, maybe that's a little naive of me, but I don't really see the Democrat or Republican comes into it very much. The pressure, perhaps, yes. However, the decision, I really don't want to believe that, because that's now how our system is set up. Okay. She has made, she sometimes, and I put that word sometimes in there, and I think it should be underlined, because yes, she's made a few rulings that did seem to favor Trump. Well, on the benefit of a doubt, maybe that's where she's leaning. Maybe like everyone else, because they're screaming so loudly that they're being persecuted, she's trying to make sure she's not adding to any bias. Okay. Some legal commentators have even accused her of sabotaging the case with her rulings, especially since she's not putting them in writing right now. She's doing delays. Her setting the date of May 20th was said to have been strategic to keep the DC lawsuit from going forward, because that was around the time that Chutkan was looking at putting it on the calendar for her court, which is held also now currently. But I don't actually think that a judge, you don't get to be a judge by acting like this. Okay. I really don't think that Judge Cannon is really going out of her way to sabotage any kind of a law case. I mean, who would do that to their own career? I really don't see that happening. Is she being extra cautious? Absolutely. Is she under the microscope from everybody? Absolutely. But I think she takes I think she's taking a harder, people are looking at her harder because of the Trump appointee. And I don't really think that's fair. I don't think they're basing their whole opinion on that. I do think they think some of the stuff that she's doing is, they don't understand. Okay. But I think they just got to pull it back just a little bit. I really don't think, like, I've even seen people say, like, oh, she obviously must be in their pocket. And I really think that that's unnecessary and not something, not something valid in their statements about it. Soon after Trump was charged, though, Cannon set the case for May 20th, as we said. And we also said that it was supposed to come up for being firmed in on March 1st hearing, which it was not discussed. That hearing did take place, but there was no replacement date list, although all sides admit that the fact that they're going to go through the trial on May 20th is some pretty mute, and they were looking at summer dates to begin with. But a lot of people are focusing on this one because they want the documents case, because that does involve how someone acts as a president. They wanted it resolved before the election. And there's two sides of that coin too. One side doesn't want it handled before the election, because they say that would be prejudicial to Donald Trump. But he's already charged with it, and he was charged with it well before he was, presidential candidate. Although he always is saying he's a presidential candidate. Okay, I get that. But there's not a reason not to look into wrongdoing, and he was charged legally through the indictment first, through a sealed grand jury, through a difficult case, because it's hard. You can't show everything to everybody, and everything has to be of the highest priority for security clearance. This is a very, very difficult case to manage. I don't think anybody would. I think you would rather have it over with, because it's going to be hanging over his head for the election. Also, if he's not guilty, there's really nothing really to worry about. If there's enough there, and his lawyers are confident that they can turn this around, that it's just procedures were followed and this and that. If they can show that there was security, which they haven't been able to, and stuff like that, it wouldn't be as offensive. But it is kind of embarrassing when you show security documents in boxes all over a public place that's accessed by anyone from around the world. And one of the major concerns is the international traffic that goes through Mar-a-Lago. It is a hot spot for smoozing. you know. And Trump used it to entertain foreign dignitaries from many, many countries from all over. And this is not all tracked because it is a public facility that people just rent rooms and stay. And, it's a country club. It's a big facility. Okay, they don't have control over all that. It's not like they check your itinerary or where you're coming from or what your purpose is when you're there. The one of the concerns was the fact that these documents were not well secured. So let me just look through the chat really quick while I. There's a whole lot of things judges do that we don't understand, and it has a lot to do with their training and experience. Exactly. In the deep knowledge that they have of law and case law that we don't. And don't forget they use precedent. And that's the other thing. This is most of these cases have no precedent. That it's very difficult, or the precedent isn't exactly the same thing. So it's got to be looked at very carefully. And some of the judges have been very good in laying out their decisions based, and they will cite case law. Judge Chuckins motion in orders, when she puts the case law there as to why she's deciding everything, was pretty clear, and showed that she had a great knowledge of the actual issues that were the legal issues that were at play there, and was actually assisting both the prosecution and the defense in where they should be looking, for some of the case law here. And like Juan Merchant, the same thing, even in his gag order. Okay, how he's trying to protect constitutional law and free speech, and at the same time the process, the judicial process for extrajudicial statements. Not every statement that we make is protected by free speech. And I mean, we do have free speech. I don't mean to say that. I mean about accountability and recourse. I mean, you can't violate a court order just because you have free speech. A court order exists for a reason. And sometimes, your free speech has to be tempered just a bit to protect others in the process. It's uncomfortable. Nobody likes to say, like, hey, you shouldn't be talking about that. Nobody wants to put those kind of chains and restrictions on people. But it has to keep happening when common sense is in when there seems to be the twisting of that right and freedom to intimidate others or to actually interfere with the process. And that's the part that people are missing. If you go and read Juan Merchant's gag order, is actually a protection of the process too. I mean, he's got to balance that also. Okay, he's not standing out there saying, "Hey, don't talk about me. I don't want to hear it." That's not the case. He's trying to keep people involved in the process that don't feel intimidated or harassed or threatened. Okay, to be part of the process, and I think that needs to be stressed a little bit more. Nobody's saying like, "Hey, you can't talk about me. That hurts my feelings." It's not about that. It's not about that at all. That's why the judge and the prosecutor are excluded from all the gag orders, because you have a right to say how you feel about this process that's going on. But you can't be like, why do you have to go through everybody's family and everything and bring stuff up? I don't understand. And coming from a large family, I would say we all have political opinions, and not one is overly influential of another for our positions and everything. To say that one merchant can't be a judge because his daughter has a different political, can't be an unbiased judge because his daughter has a biased opinion about something, or a stronger opinion or a different opinion than a defendant in his case. Well, if that was the case, we couldn't have a judicial system. There wouldn't be a prosecutor, a defense attorney, or a judge sitting in this process that could actually be on a case based on what their family, their partners, or someone their best friends' political opinions, stances, and advocacies are. It's ridiculous. All right, it's just going a little too far. But we'll see. We'll see what happens. It's a live motion. They're stating that they're going to be bringing that motion forward. I want to see what happens. They've tried to remove Juan Merchant from the New York case before. But okay. Let me just go through. Okay, I answered the attorney question. I'm just going through to see if I've got questions on here. It can be. I get this, Liam, when other judges are actually saying, what are you doing? That we need to be wary. And they are looking at it. I mean, that's what I mean. They're under, all of them are under such scrutiny. And no one wants to be overturned by their peers, you know. Hello, Jean. Welcome. Thanks. But it was, I don't know if it was a locked bathroom. It was one that wasn't used very often from what I read from one of the witness statements that was quoted. All right. All right. Let's go to the second case. Okay. This is the DC case that special counsel Jack Smith brought in regards against Trump back in August. Let me just bring this up. Back in August of 2023. He was indicted in August of 2023. The judge is Tanya Sue Chutkan, as I mentioned before. The courts have denied presidential immunity on state appeal. The DC, she denied it. It went up. They upheld it, but it's going to the Supreme Court now because there's a level of appeal that goes. So it is going up again. Okay. The gag order to protect the jury in the process is in there. They had previously listed attorneys Blanche and Lario as the defense attorneys for Trump. The trial date is currently held, or it was tentatively like on the books for late spring, or but it's not now. That's because clearly, why go through all of this with the motions and everything if the presidential immunity tosses the whole case? And since it's called at a higher level of Supreme Court, she's actually, Judge Chutkan had already ruled on it. The state court of appeal has already, looked at it, and so we're just waiting. We're waiting. They're going to hear it, I believe, April 22nd, if I got that date right. This one includes 2 felony accounts, including one conspiracy of obstructing an official proceeding under the, the Documents, the Documents Act. Okay. It's another one to defraud the United States. In the interference of things that were done. It also has stuff in there about January 6th, but it does hold back from actually calling any of that an insurrection. But it does say that to defraud the United States, this was against this was about going against the American people, picking a president, and then not going forward and ratifying that election, actually getting in the way of actually the process of having those votes put in and the transition of power from one president to another. Special counsel Jack Smith has brought forth our rights that that was a fraud against the American people and the government when you did that, not just like, hey, to continue to say that you're president and everything else is moot, and to deny our votes, which is a sacred right here in America, our right to vote for like who we want. That is the cases there, and there's case law against that. That was kind of the vote. This is Judge Chutkan. Okay. She is well appreciated for her standings in law, in her knowledge of law in cases and how she uses them. I'd have to say that her briefs are very, very well written. She seems to be well thought out, middle of the road, doesn't seem to be, too aggressive in her decisions. However, the Trump defense team has brought up that she has actually sentenced quite a few of the January 6th violators in cases that are thousands and thousands of them on the books from that event in January 6th. And those sentencings and trials are still going on in regards to what happened on that day. That is still happening every day here in every court around. All right. Every day I see sentencing of certain people. We've seen certain leaders of certain groups go under sentencing and have trials. Judge Chutkan has done some stiff penalties to rioters in the past. So she has actually done sentencing on those January 6 cases also. And that was one of the objections of the defense team and Trump as her being a trial lawyer for the. Well, she was drawn randomly from the pool. You see, like that's the process they forget to tell you. They say that they stack the deck by picking these judges. These judges don't get picked. It's a pool. It's a random number draw. Okay, and they serve the case. They don't get assigned based on what the case is. So there's not really a way to stack the deck by saying this prosecutor, this judge, this. I've seen quite a few people out there toting that line. Thankfully, not too many of the commentators and the actual, that the legal channels that I do watch, they go, they actually put the real information on there about the whole process, and they try to debunk that right away, because it is disheartening to see that people are out there speaking about it and they don't even know what the process is. There's no way that she actually petitioned to get this case because she wants to put Donald Trump away. Okay. No, it doesn't happen. Same with Juan Merchan. Like, he didn't go, oh, hey, give it to me. Like, I don't like the guy. It doesn't happen. These are random draws. Okay. All right. We were going to have this case. We should have already started this case, actually. But it's on hold while the Supreme Court hears a case about whether the former president should be immune to prosecution. A 3-judge panel rejected that claim on February 6th, and Trump appealed, so it went up to the Supreme. Rejected that claim on February 6th, but the justice will hear the case the week of April 22nd. A window for trial to occur before the election is narrowing because of everything. Like, they have stopped all the motions in this case. As with the other Department of Justice case, the Mar-a-Lago case, time is of essence, because Trump or any other Republican president could shut down a case upon taking office in January 2025. And that is because this was done by the special prosecutor in the Department of Justice and anyone in office. And that means not just a Republican. A Democrat could do the same thing. So they don't mean that like only a Republican to do it. That would mean anyone coming into office who has, because remember, the presidency is the head of the justice system. Just like he's the head of the military. All right. So here we go. Anyone could throw monkey wrenches into that process. Once anyone new coming in could do that. I mean, Joe Biden could too, although he stayed away from it. Like, he's trying to do the best he can, although because he is the president at the time, he's going to be linked to it no matter what. No, there's no avoiding that. All right. Well, it doesn't mean just anybody. They don't. I don't mean to single out Republicans. Is what I'm saying. Okay. I'm gonna go and look again for questions before I move on. It's your right to vote is sacred, then use it and get out there and vote. Exactly. I feel that way. I feel we don't ever, if we don't vote in the system that we have or try to change it, like, a lot of people just want to say it doesn't work and back away from it. It's a system that we have. I don't think we should settle for it. I do think it needs to change in a lot of aspects, and nothing's perfect. But those who don't participate in actively changing it, that sit around and just complain about it, well, that's not really going to do anything. Hey, Galloway Raider, nice to see you. It's Chuck Han, right? As if she's an ice cream bride. I get it. Liam, it's just the pronunciation of the name, but yeah, people can be rude. I get it. It is just I'm doing an overview of the cases. All right, so I don't see. All right, so in regards, back to the case. The case rivals the Georgia case, which we're going to talk about next, which had a lot of fireworks going on and is very contentious. However, the focus is just on Trump with this one. Okay. With this case that Jack Smith brought, the symbolic weight of the U.S. Justice Department prosecuting an attempt to subvert the American election system is a heavy subject. And this is hard to say how this path to verdict is really going to go. We've not been here before. And I'm sure that if you watch any of the commentators, you watch any of the legal channels, they're going to say, we've not been here before. All right. Smith avoided some of the unconventional potential charges that he could have gone for, that most people were thinking they would go for, and are like some people I've seen go really hard, very disappointed that he didn't, about going after the insurrection part. A lot of people watched this crime unfold in real time. However, there's no precedent that exists for a case like this legally, or with a defendant like this, an ex-president running again for election. We've not been here, okay? We've not been here before, so the precedent doesn't exist. So it really could go either way, either way. But it is a very important case. I think the handling of those documents gets poo-pooed because people feel that Trump is being pushed on relentlessly because of the amount of cases that are coming out. But I'd say if you look at each individual case, there is something there for all of it. And a lot of it has to do with the January 6th, especially the Georgia case does, okay, with all those defendants involved. There's going to be state and federal. Every state that feels that they were tampered with in some way could file a case like the Georgia one or something similar, based on what they think happened within their state during this very contentious. There was actually something there, and it's not as uncomfortable as it is. It's not something that we can deny or that we can just walk away from. It does need to be looked at. And if there's nothing there, he will walk away with no problem. But something needs to be looked at there. There was a lot of people involved in this. And laws were broken. And those laws are this is the process. This is the system that takes care of that for us, because no one should be above the law. Now, presidents should not be hand tied to where they can't perform their duties. But is it your duty to deny an election? So there's two sides of that coin. Some say it's self-serving. Some say he was serving the people. But the people voted. And there is no proof of election tampering. And that's the cusp of most of these cases, that without any actual evidence in multiple investigations, remember, there were 3 investigations into election tampering. His own investigation, and when I say his, I mean the Trump cabinet, Trump's presidency, everyone in charge there did their own investigation. His own campaign did an investigation and did not come back with evidence of election tampering. His own advisors were telling him so. Some of these advisors are actually testifying to what happened at that time. And some of it is not favorable to Trump, because he said that regardless what, this is what he believed. And was his belief over this to protect his own presidency that he lost an election? Does that mean more than the actual process and the system and the laws that we have in place? This is where people get so upset, and I kind of understand it. But to think that everyone in the world is organizing against you because you don't like it, well, that's not really common sense either. Okay. And my tenacity, you know what? I'm glad you recognize that. I want the information out there. And even if I'm not a Republican, I don't want to be saying that I just don't like what's going on because I'm not a Republican. Yeah, please don't use words like that in my chat, Doug Galloway, or make accusations against anybody. Like, that's not what this is about. This is about looking at the cases, okay? And I'm trying not to I'm trying to be as fair as possible, you know? Yeah, I think they have looked at that laptop, Galloway. I really have. And I think that we could go into that, and I would be willing to talk about it, but I would like to continue with my stream and not worry about the gossip and the name calling and evidence. And I assure you, if they do file charges against anybody else in regards to the stuff that you are talking about in the chat, I would definitely have that up here too. I would. Okay. I think it's unfair to think just because I'm speaking about it that I wouldn't put the other side out there. I appreciate that. Thank you. So, based on the fact that one side thinks that the special prosecutor didn't go hard enough, and the other side thinks that this is all just bullshit anyway and shouldn't even come to light. If I had to actually say what I think about it, I think that it should be looked at. And then if there's anything to it, it will pan that they do believe that there's something to it, or they wouldn't brought charges. I'll say that. But that the American people have a right to know that it was looked at and it was settled. And it shouldn't be just farmed under the rug, so to speak. Okay. I really don't believe that there's an organized conspiracy against one man because he wanted to run for president. I do agree that there's a large faction of people that don't like that man, okay, and don't want to see him run for president again. But to say that they're using the legal system to prevent it is not, because this I will stand on. Filing of all of these charges, in my humble opinion, so let's be clear, this is just my opinion, has helped his campaign. It has given him the rhetoric and the fire and the fuel that he campaigns on regularly. It has given him things to point at in regards to the system that many people believe are going on, and just to write it up. If anything, it has helped him. If anything has helped him, okay, in regards to getting more message, to keeping him in the news cycles. As far as PR goes, there's no downside to this, okay? There's not. It's gotten him, Donald Trump himself believes that, there is no such thing as bad press, right? So I really actually think that if there was a conspiracy to do all of this, it would have been done a lot earlier. I think that they were overly cautious in checking everything out before they brought the charges, and they took their time. Nobody wanted to get into this snarl of a mess. This is a mess. This puts our whole country under a spotlight. And it's a mess. There's just no doubt about it. I'm uncomfortable looking at it. Okay. And I believe in law and order. I love the judicial system, the legal system. Yeah, come out here and I talk about Trump, but because I say the word Trump, do you see the bullshit you got to put up with? Like, really? And I'm not even saying anything horrible about him. I mean, yes, I do joke about him, and come on, there's plenty there to joke about. The man goes out of his way to make himself a cartoon, as most public figures do. Let's not forget that. All right? Yeah. Listen, and you know what? That's a true statement, Galloway. In many cases, these cases are based on things that others have done just as bad and just as worse. But that's not what we're talking about. We're talking about these cases. And they should try those other cases too. And they should, that people that do the same kind of stuff should be charged too. And I stand behind that. It should be fair all the way across the board. Yeah. Yeah, it is. And thank you for being respectful. I don't mind the other side of the coin. It's just there's like a time and place. Like, I'm not the one making the decision on whether these cases get filed, and we're never going to know. Like, they can make innuendo about all the backroom stuff that they want, but nobody's ever going to know. There's always going to be like stuff like that going on. There always will be. All right. Okay, that was it. Blank, because we don't know what's going to happen yet. We don't have a case. We don't have a case yet. But let's go on to Georgia, okay? If that's okay with you guys. I would just like to get Georgia on the books here, because this one was hot. Just a brief refresher. This is the indictment that blew up with 18 co-indictors, okay? 41 charges in 98 pages. It was done last August by Fannie Willis in Georgia. 161 documented acts up on a RICO charge. There is a law on the books in Georgia that actually links RICO and conspiracy, which she was able to use to bring these charges for. She's the district attorney. The judge in this case is Scott McAvee. And the attorney of record for defenses for Trump's team is Stephen Sadlow. He's been in most of the motions. I've been watching the motions going forward in Judge McAfee has a YouTube channel. So everything has actually been in the open in Georgia for all of these motions. They had a motions hearing in December, but there was a decision was pending. They were going back and forth on striking some of the cases. There were motions from defenses that they couldn't be prosecuted because they were in government at the time, that it should go to federal, it shouldn't be a state case. There was multiple motions filed by multiple defendants. Remember, there's 18. There's Donald Trump plus 18. And there's a whole bunch of unnamed co-conspirators that are listed in there. And one of them that people have thrown the name around, John Eastman around, they say Rudy Giuliani, stuff. But on the John Eastman end, just of note, a California judge just came forward and said that he actually should go up for disbarment charges. And she has ruled against him in quite a bit of things and was quite upset with him. And he's got his own legal trouble there. And he actually indicated that he had stuff to worry about here in Georgia that he had to take care of. So there is a lot that he's one of the unnamed co-conspirators, because we know from what happened and what was reported at the time who all the players were and who were involved. They had originally put stuff forward to coming through that perhaps in August we would have a trial on that. There was a motion to quash the special grand jury disqualification of the DA office, and the judge ordered on a special grand jury report certain public portions to come out. Willis has put a letter out on the timing of potential charges, and to date we have 4 guilty pleas already from some top lawyers. Okay. In this conspiracy, basically in the affidavit, which was in public file on my previous documentation, if you need a Google link to that, I can get it. But the link that I put down there from this one site called Just Security does list all of the indictments and a lot of the more important motions and happenings in the court course, and they're covering it like information for lawyers. So it is pretty valuable if you like to read that kind of stuff. Okay. But remember, an indictment is just like the prosecution side of like, this is what happened and this is why we're going forward for trial. Goes through all of that with the grand jury before indictment like actually happens. Both the ex-Trump attorneys Jenna Ellis, Sidney Powell, and Kenneth Cheeseburger, and the Atlantic-based bail bondsman Scott Hall, who are all part of the original 18 named, have gave prosecution statements required as part of their plea deals. They pled guilty, every single one of them, to a majority of the charges. They just adjusted some of them down. They cut those agreements with the Fulton County District Attorney. That was months ago. That is all on Scott McAfee's YouTube channel. The judge, you can actually watch those hearings and the statements that they gave. They actually gave apology statements that were required by the DA. But it is a big racketeering case, okay, with the former president and now 14 others still left pending, which shed further light on efforts for Trump not to leave the presidency. And basically, it regards the false electors conspiracy. It involved quite a few charges in regards to phone calls that were made trying to secure votes, a lot, just basically how not to ratify the election going forth, and actually making a plan. And conspiracy is one of the charges in here. It is a serious indictment. It's a very serious indictment, and it's what the legal channels are saying mostly. And I don't, is that it's the law in Georgia that made it evident that how she could approach it like this way, in regards to the RICO, in bringing everybody together under one indictment instead of individual ones. More than any other case, they're stating that this one attempts to reckon with the full breadth of the assault on the democracy following the 2020 election, because it clearly indicates in the indictment the steps that they took or that they allegedly took. Let's be clear. We're saying allegedly. This is an indictment. There's no trial yet. We don't have guilty. It just paints the picture of everything that was allegedly done to not to interfere with the results of this election and to actually go forward after the results came forward to not have it ratified. A lot of the experts differ. It's a huge case. Racketeering a law, like I said, legal experts are saying it allows Willis to sweep in a greater deal of material and is strong evidence, like that call to which Trump made asking the Georgia secretary, and many of us have heard it on the media, to find some 11,000 votes. Could he just been saying what he needed? Was it actually order? Like, that's all up for a jury and speculation and all of that. That's if it even gets in there, because I've got more news on that particular one for sure. But 3 major plea deals from the defendants could also easily have the verdict. You already have people acknowledging what they did in regards to a conspiracy of this nature. They are actually admitting guilt and saying that this is true and this is what happened in regards to that. And part of their plea agreements is that they all need to testify in this case or any other case involving these actions. Getting a jury, however, to convict an ex-president or a current presidential campaign, or just the fact that he's Trump in general, is still going to be a challenge. It's not happened. Like I said before, there's no precedence it's not happened. Everyone involved in these cases has got to be uncomfortable. I mean, just reading into them and seeing what's going on, I'm uncomfortable. This is all new ground. Nobody knows what's going to happen. The case was delayed and hurt by the revelation of a romantic relationship between Willis and attorney Wade that she hired as the special prosecutor. A hearing of many days was handled. That's also on Scott McAvee's YouTube channel, The Judge. And it was held after motions by defense to remove Willis in her office and toss the charges. It was twofold. Okay. On March 15th, Judge Scott McAvee declined to throw out the indictment, but he sharply castigated Willis and said that either she and her office or the special prosecutor must exit the case. Wade has since resigned, and that was rightly so. And Judge McAvee, although he said that there was a case there that they did prove there was a romantic relationship, they didn't prove, which they needed to under prosecutorial misconduct, that she actually had any financial benefit here and there. There really wasn't enough there. They took vacations together. I listened to those things. She did pay him back for money. They could not prove that she benefited from the relationship financially or to anything of that nature. Although he did say it was bad judgment to hire him. It really makes it look like, and has the stink of impropriety, which everyone should avoid. In a case of this magnitude, people would want to avoid that kind of stuff because everything's under a microscope. So he was not happy about it, and he did chest hit, and she should know better. She really should have. But was it enough to actually say that she had no right to bring charges against the defendant because she slept with a gentleman? No, they have to prove that it will actually interfere or caused any of the actions, and they weren't able to do that successfully. Although they did go through all the paces, yes, they did, and they went through it. It was like a 3-ring circus. It was painful to watch. They do have a point. It does stink of impropriety. I don't really think she did anything horribly wrong. Well, did she have to hire him for one of the biggest cases out there that people are going to be looking at? And there's no way that this wasn't going to become an issue. I wish that they had thought more carefully about, bringing him onto the prosecution team as a consultant. Because there's no getting over it now. It does look bad. Okay. It just, it gives them all something to talk about. And you know me, I'm like, why? Like, think about it a little bit ahead of time. Why give them something to say? It's only going to make things messy and deter. Should it matter? Fannie Willis will say, like, should it matter who I sleep with? No. Like, I can have judgment on my own. I'm an independent woman with independent money, making my own decisions here. I am the district attorney in Georgia, and I brought these charges, not anybody else. But McAvee was right. Although only one of the two could stay there. She and her whole team had to leave, if they weren't going to if they were going to continue with Wade. There's just no way. He also wrote that failed to, as I said, they failed to meet their burden in proving District Attorney Fannie Willis, the lead prosecutor Wade, was a conflict of interest, but it wasn't enough to merit her removal from the case. But he found impropriety. He also removed several indictments from the case. And this is where it gets interesting, because McAfee squashed counts 2, 5, 6, 23, 28, and 38, all of which focus on alleged efforts by the defendants to solicit public officials. Now, this was really, really important, because the solicitation of public officials, that's just the outright, like, severe penalty, just wrong, including the Georgia Secretary of State, rather, and members of the Georgia House and Senate to violate their oaths of office. Like, this is serious here. So what he said, that there was not enough, that they were using constitutional statements that were so broad, points of reference in law that were so broad that the defendants would not have the ability to defend anything against them. So you really can't do that. It's kind of got to be fair. You got to say exactly what it is you're accusing them of. And although they outlaid the scenario of what happened very well, what they didn't do was point to exactly where the violations are enough for the defendants to defend against them. He stated that the prosecutors could appeal the ruling or ask a grand jury to produce a more specific indictment on the removed counts. In other words, he said, like, there's enough there as far as the story that you're telling, but you're not actually pointing to something that the defendants can actually latch onto for defense. So in other words, that's not fair. So come back with that, take that to the grand jury, which from what the legal channels are saying, and the even the political commentators are actually weighing in on this one. And actually they're saying that would probably be the move that would be the most prudent, is because it's the easiest and the fastest, and she just has to, basically dot her I's and cross her T's, and they will come back into play, because he did not strike them as a matter of law, and he did not strike them as a matter of being invalid or nothing there. It's kind of like a procedural kind of thing. And in fairness to the defendants, let's be clear, this judge also is being very careful to make sure that this trial, should this go forward, as far as appeals and judgments go and motions, that everybody's side is being taken into careful consideration in regards to the law. And when he says that they can't defend against it, well, that throws our whole system into jeopardy, because you have to be able to defend against the charges. Okay. Too broad, just too broad an incitement. Exactly, Liam. That's exactly it. As he said, this is a quote from him. As written, these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission, i.e., the underlying felony solicited. He wrote, they do not give the defendants enough information to prepare their defenses intelligently, as the defendants could have violated the constitutions and thus the statute in dozens, if not hundreds, of distinct ways. It was just too broad. And that was that. So on that case there, we're waiting on that motion there. We're waiting to see what Fannie Willis is going to do in regards to those motions. But the rest of it, the actual RICO conspiracy part, and the parts that actually, like, let me just pull it up. For Donald Trump in particular, as one of the defendants, I think he still has 3 or 4 major charges against him. Okay. And I'm going to pull up exactly. Okay. On this case here with McAvee's squash of those ruling, okay. He left mostly intact almost all of the racketeering indictment, which originally included 42 counts, and what is it now, down to 36. It is going to be a setback for the prosecutors, because they have to decide, like, what they're going to do about those charges before they go forward. But it doesn't weaken the core of the case, which is racketeering charge that was brought against all of the defendants in the election interference. Okay. the racketeering charge itself is based on overt acts that the indictment says various defendants took in furtherance of a racketeering conspiracy to disavow the election results. The judge was explicit in stating that Wednesday's order, this happened last Wednesday, does not apply to those racketeering charges. Okay. This ruling is not related to the disqualification motion that was put forward to remove Fannie Willis. This was a separate motion in regards to actually throwing out the whole indictment. Basically, he focused, like he said, mostly on the solicitation against other public officials in office. Okay. The one that related to the phone call was count 28, and that was the one with Mr. Raffensperger on January 2nd, in which he pressured the Secretary of State to find him enough votes. We've all kind of like heard that conversation. We heard it in the January 6th hearings. We've heard it. It's been all over the media because it was released. They demanded that all of the evidence be released in the January 6th committee. And so it all was, and we all heard it. They wanted that committee publicized, and everything was there. So some of the evidence for some of these charges is actually coming from in there and has been affidavit. Other ones, 2, 6, and 23 allege that the defendants broke the law when they urged Georgia lawmakers to appoint pro-Trump electors after Biden had already won. Actually, the appointing of electors after that fact is one of the reasons that these charges were filed. But it's the conversations and all that they have here. They want to see what violation actually, where the felony actually starts to exist in the racketeering. Count 5 concerned a call that Trump made to David Ralston, who was Speaker of the Georgia House. These are all Georgia officials because, this is the Georgia conspiracy racketeering case for election fraud. He wanted Ralston, he being Trump at the time, during that call, wanted Ralston to call a special legislative session to appoint new electors. It's all about the appointing of new electors. They wanted to throw out the electors that were there because they were going to ratify the vote, and they definitely wanted new electors in there that wouldn't. Most of the charges in this case are against Rudolph Giuliani and Trump himself, who faced 13 apiece, but now only face 10 because 3 of the 6 charges, counts that were struck to be redone or dropped were on them. But now they still face 10 each. 4 of the other defendants face fewer charges, including Mark Meadows, who now really only faces an obstruction charge, I think. I do believe. Ray Smith and Robert Chile, rather, both are going to have their charges reduced in regards to that last ruling. Anthony Creese, a law professor in Georgia State University, gave a statement that notified that the prosecutors could appeal the judge's order, or they could just go to and do detailed versions of the challenge charges before a grand jury, which would issue a superseding indictment or an amendment to the indictment. For that reason, the racketeering charges are really not affected. And it could go forward as it is, or we could see some amendments to the charges or more motions in regards to the indictment itself based on this ruling of McAfee. We'll have to see. But either way, it's only, as far as the case concerned, it doesn't stop the case from going forward. Some call it like a great win, and in a way it is. Anytime you get charges removed from an indictment distraught, that's heavy, not good for the prosecution, and it's good for the defendants because it's less you have to defend against. Okay. They do see it as a victory, and I would say rightly so. I mean, they've got a lot less to worry about with that off there. They've still got a heavy case to defend against, but there's less they're going to have to defend. They do think, if you listen to the defendants' lawyers, and there are a lot of them because there's a lot of defendants. When I was watching the hearings, there were so many lawyers that had to speak regarding all of the defendants there. There was like a sign in and sign out, like who's here for who. And, every time a question came up and they would ask, like, go all through. That was, for me, that was interesting to watch. I had not seen that many lawyers in a room representing people all together in quite some time. Mm. But if you listen to the prosecution side, people that are saying, they're saying that this isn't going to affect the case, that it's full steam ahead because of the RICO portion of the case, which is the most damaging for them. And RICO stands for Racketeering, Influenced, and Corrupt Organizations. In other words, they formed a little organization to do a corrupt act and conspiracy, which would be to interfere with the Georgia election. Okay. Also, the governor in Georgia has not let any of this actually go without a statement. He signed legislation that will allow a new state commission, which has the ability to remove prosecutors, and they're going to be looking into whether Miss Willis conducted her relationship with Nathan Wade, in whether that is actually a reason she should lose her position. But they are actually looking at it too. There's more to it than just what Judge McAfee did, although the case isn't going to stop here based on that. She is under scrutiny in her own state. There are opponents of this particular commission that are trying to stop its formation because they do think it's a political thing. But I actually think that, like, everything does need to be looked at. I don't think um in her own department, she must have had rules that she had to obey, and they actually should be looking into that to make sure that she did. I think every needs to be dotted and every T needs to be crossed, but there's a lot of scrutiny on this case and nobody is above it. And they can't say, like, call foul. They're going to bring a big public case like that. There's going to be a lot of scrutiny. You got to be prepared for the fallout of what's going to happen. And right now the focus is on whether there was any improprieties there, and if they feel there are, they should look into them. Now, Joe McAvey did in regards to the indictment and the charges and how those charges were processed, and he felt that there was not enough to remove her, that it did stink of impropriety because the relationship happened. But did it influence anything in regards to the case? No, they didn't prove that. That's what he's saying. In other words, like, if we paint a broader picture, it's not like she was paid to bring this case forward. She wasn't bribed. She wasn't influenced by any money. Trying to make a big name for Wade, or not, Nathan Wade or not. There was she feels the personal and the professional part really didn't bleed over. Anybody looking at it would find it difficult not to wonder what is going on there, if there is both a personal and a professional relationship. Well, did it actually have anything to do with the filing of the case? Probably not. Should they serve on cases together? Probably not. It does stink of impropriety. It does. You kind of agree. McAfee was in a tough position there, and I actually think the ruling was good. Not being a legal mind, I'm not a lawyer, but I actually think he balanced it pretty well. Yeah. Does charging the judge's daughter make it a case with kids involved? Which case are you talking? Juan Merchant's daughter is an adult, a political advocate. She has strong opinions on politics and stuff, which is why she's being targeted. She is an adult, but she's his kid. But he said family, so it does qualify that she can't be talked about. Yeah. You mean on the bingo card? I can't imagine a room full of lawyers actually coming up with valid strategy to construct a case. It would be bedlam. Yeah, it does. It seems like they all have different things to say about stuff. Like, because it's all the defendants in one case, and then there's the prosecution table over to the side. It is all of these different attorneys, and they're all protecting their clients' interests, and all of the clients have different degrees of culpability in the indictment too, is regards to the number of charges, the counts of the indictment that are assigned to them. Okay. So it's different. Like Mark Meadows is only under one now. And he actually just filed a motion. He wants a hearing on evidence to actually get out from under this now. Like he's actually filing again. He has also filed previously for venue, previously because of jurisdiction, that this should be heard federal, that he was a federal employee at the time because he was chief of staff at one point. And he tried, but a lot of this had to do with the campaign. And so a lot of the conversations that Mark Meadow had been documented as part of the counts against Mark Meadow were actually with campaign people and in regards to the campaign. And so that's why the judge kept it in Georgia where it was, because of that. It wasn't actually acting as a chief of staff, although it is valid that the chief of staff would want to know about what's going on with the campaign involving his chief. That's true and legitimate and reasonable. I get that. There was a reason he was there. I get that. So that's going to be, a good argument back and forth in regards to that. But as far as venue, it stayed in Georgia, his case. For now, we'll see if Judge McAfee grants that hearing. And if they have that hearing, it will be on his YouTube. Okay. And we'll get to see how that goes. Appearance is a term which can encompass so much that Fannie should have been a lot more self-aware. Exactly. And I think that's what the judge said, that it was a shame that she didn't take all of that into consideration, or at least disclose it before anybody else did. Because even if it did have this sense of impropriety, because they had this relationship before this was filed, if that was before she hired him as a consultant, it should have all been disclosed. And then at least they would have all of that backing. Now, I'm not going to say that it wasn't, because I don't know what the actual human resources department requires in the DA's office in regards to all of that. I did not check that out fully. Okay, whether they need to disclose if they're going to be working together, or if she's going to petition for him to be hired for any services. And that seems to be one of the issues here, is that she needed to put forward that he should be hired to come on board for the prosecution team. Okay. And he is going to get paid money from the state. So like, what was that process all about? It had to go through. And I'm sure if there was any impropriety there, the defense would have used it had she violated it, and it would have came up in those hearings. And I'm not recalling that it did. If it did, it was very minor and it was like pushed over. It wasn't like a big deal that I saw. I'm not saying it wasn't. I'm just saying from what I saw. But I didn't watch every minute of that because it did get to be quite tedious after a while. There were so many of them and it took so long. Considering my main experience with lawyers is Amber Heard and Sovsits, I imagine it would be hell to get through anything without 45 objections per minute. There was a lot. And there was a lot that they wanted to handle motions for other things. And McAfee's got his hands full. There's a lot of defendants. There's a lot juggling around, but he's trying to be fair. Well, to be honest, he's got his own campaign going right now too. I think he's running for some type of office. Also, and there's like political concerns and pressure. Like I said, all these judges in bringing forth these cases, the one thing I really wanted to talk about the most is the spotlight that is on all the judges and the law here, and that we could be learning a lot instead of bickering back and forth with each other on whether or not he should be charged or not. Yeah, that's a conversation. And yeah, I'm not saying that conversation doesn't exist. I'm just going to say there is no real good outcome of that conversation except for a debate where people just think the whole system is corrupt and none of this should be happening. There are people that believe that Trump is being targeted. There are other people that believe, no, we're just sick of him, like not being accountable for breaking the law. I've always been honest that I live here on the East Coast. There's been issues with Trump all along, well before we got involved in running for president or doing anything like that. There's been business laws, there's been breaking, there's been real estate violations going on. There's been 4,000 lawsuits in regards to bad business deals, in not paying people, in violations on buildings, in blah, blah. And there's always the, well, everybody does it, like, reason that Trump throws out there, which he did in his New York civil fraud case. He said the same thing he's been saying for 30 years. He hasn't changed. All right. Trump has not changed. He's not anything new. He's the same as he's always been. He does nothing wrong. It's everybody else. A lot of people are like that. Okay. And a lot of people, get pushback for it too. My only point is, I don't want to have arguments with people that think that anybody's above the law, that just because he's Trump, he shouldn't be charged, that this is some kind of persecution. It is some type of persecution. I hope it's outed in that we see it. But the more that we keep talking about it, that he shouldn't come up on charges, that's offensive to me. Because if these prosecutors, I don't believe that every prosecutor is bought and sold. I don't believe that the judges that sit on our, all of them are bought and sold. Do I think that it happens? Do I think corruption exists? Do I think that there are bribery and that people are bought and sold every day? Yes, I do. I'm not an idiot. That's not what I'm saying. I'm saying to come outright and say none of these charges should exist because it's just persecution for a political reason. No. If that was the case, all of this would have happened without it even being fully thought out, and it before the last election. Okay. Some of these charges could have been filed after the last election. If it really was some kind of thing that they just like were out to get Trump, they could have just did it then. Okay. But based under the Espionage Act, he could have been freaking, like, most people that are under charges of the Espionage Act, they're not walking free. They're in handcuffs waiting in Guantanamo, in Guantanamo or wherever, Guantanamo Bay, waiting for a trial or whatever. Okay. That old saying, like sit and wait, like but you're not going to hurt the country anymore while you do it. Yeah, some of these charges are quite serious. And actually, I do think that there is caution being taken by the system. And I know a lot of people think I'm naive for it, but that's how I see it right now. I actually think bringing all these cases forward is not a hindrance to his presidential campaign. It's actually helping it. It gives it the platform to run on and to push against, which something is an environment that no one could deny Donald J. Trump thrives in. Okay. And so, like, to say that it's detrimental to him in that way, I really don't agree with that. Do I think there are political involvement here and there? Absolutely, because there isn't anything that happens in this country of America that's not political. Y'all make it that way. We all make it that way. I'm not blaming anybody, but myself too. We all make it that way. We all do it, But what I want to see is the legal precedent that gets set in all these cases. If the reason I am speaking out on and giving the information on the Trump cases, I'm going to be really honest with you here right now, is every single one of them has a unique, never before precedent to be set. Every single one of them. We've never been here before. All sides are right and wrong at the same time in regards to these issues. Whether there's political pressure to file them, whether, like, when you're sitting there with someone interfering with evidence brought to you that there was interference in an election, that the people's rights may have been violated, that false stuff was put out, that people were just trying not to get the trial ratified, even though there was no proof that there was election fraud going on. Believe me, if there was any evidence after those 3 investigations that there was tampering, this would be a whole different story. But most of these cases are hindered on the fact that due diligence was taken and that there was multiple investigations done, and still a narrative was pushed forward that was false, totally negating everything else, just because this is what they wanted to believe. And they were doing whatever they could to prove it. At least that's the allegations. They were organizing and conspiring to prove what they thought was true, any scrap that they could. And if you go that far to do it, well, there's got to be charges, especially if you break the law to do it. It's not like they just took articles out and said it. I don't know how to say that here. I don't even know if that's how it's spelled. Yeah. It is that I have no I have no idea how to say it. I mangled it. Guitaro. Can I say Guitaro Bay? Probably better than Guantanamo. Yeah, forget it. Just, you got me. You got me. Just not a perfect person. Yeah, nobody wants to stay there, let alone have to say it more than once, Mark. Totally. But you get my point, right? I'm not like trying to bash Trump. He's an enigma. He is one of the most fascinating characters in history we're ever going to have here in America. We will be looking into the things that he said and he did and who he was and how he got there forever in our country. For hundreds of years in the future. This will be a testament of what this time was like. And I want to be able to talk about the cases in a kind of a black and white way. And so you can DM me about like how I don't want to get into great debate about corruption and conspiracy and things like that. I do know that all these things exist, but that's not what I do here on my channel. Like right now, I want to talk about giving you guys all the information on the cases. I do add opinion to it. Yes, I do. It's quite obvious I'm a little left leaning. Yeah, but I think I'm kind of middle. I do. I try to be anyway. I am registered as an independent just before you all hit my DMs about me being liberal and this and that and woke and all of that. I actually think after the last couple of elections, I actually wanted to be an independent because I'm not happy with anything that goes on either side. And the only reason I'm saying that is this is a political show. It is doing political legal, but it does say political review. So I'm being a little more open on political views about it. Um, and I still want to say that all of these charges, this is just accused. This is allegedly he did all of this stuff. Donald J. Trump, all of this stuff, allegedly. But the process is there for a reason. And if he's guilty, he should have, it will say so. If he's not guilty, it will say so. But the process should be followed. And my issue is the lack of respect for the process. Especially when you were ahead of the country that had that process. Okay. And well, we know the process isn't perfect. We all know that. But instead of just denying the process, just totally disrespecting it, how about doing what you can to change it for the better of everybody and not just one person? That could be a thing. And I know that sounds all pie in the sky and rose colored glasses. But isn't that the way of it? You can sit on your butt and mouth off about how wrong everything is, or you can use what remnants of a system that we have still and vote, advocate, let people know what you think is wrong with the system, but not telling me about it. I can't do anything for you. But you know who can? Your local senators, your local representatives on either side. That's all I got to say about that. I don't mean to argue with people in my chat about their opinions, pro or con, about anything. And I don't want to appear closed off, but I am closed off when I am actually in the middle of doing something for a different reason. I'll stand my ground. I will talk about anything anybody wants to talk about in time or place, But I, as the people coming to my chat, have a right to decide where and when. To be fair, I'm pretty good at words. I say hippopotamonastasquiptidalophobia off the cuff, so maybe it's a little unfair. I have a video where I did say the longest word ever, like that really, really long one, but I had to practice it over and over again and over and over again. And I mispronounce a lot of stuff. Yeah, I'm just human. I'm not out here as a journalist or a professional speaker. I'm just a bear. I'm just a woman named Bear with a mic. who likes to talk about legal stuff and other issues, who just likes to talk, Yeah. If you don't follow the process to the end, you leave open the possibility to challenge the result. Exactly. Exactly. And they are doing the process. There are motions back and forth on why all of the indictments should be tossed. The indictments have stood. There was legal thing there. I want to have the confidence in our system that says if the judge had the ability to toss the indictment on legal precedents, he would, if it was valid. I think these judges, the point of covering the Trump cases is they are historical. They are going to change legal precedent all over. The judges have spotlights on them to see our judicial system, to see the balance, to see how they have to put the rights of everyone and the defendant and the people. There's a fine balance, and I think they're doing the best that they can. Oh yeah, that's the big word like that there. I couldn't even. Anti-disestablishmentarianism. I can say that. Anti-disestablishmentarianism, I guess. Okay, I just mispronounced it. All right, never mind. 1 and 1. Ultramicroscopic silicovolcanoconiosis is a lovely word. That sounds like a volcano caught pneumonia and they saw it under a microscope. I don't know what that is. Wow. Okay. No, I won't be taking the word challenge. I have failed. People. Yes, there. My failures out here for YouTube, all to see. Yep. Anyway, that is part 2. If you have questions and you can be civil, please contact me. And for those of you that I did push back on, and you know who you are, I mean it. I am open to discussion. I just don't like to get derailed in the middle of my streams talking about topics that aren't involved. Like, yes, it was Trump. I agree. It was sort of on topic, but you want to broaden it to the whole system and everything else. I can't do that and stay on track. It's not fair. Just asking people to be fair. Mm. Liam, that is something that's never come up before. Do the courts actually have jurisdiction over the president? When the president is the head of the whole Department of Justice, well, the judicial system is set up to actually operate outside of governmental issues that way. Well, law is law. Once it becomes law, and the judicial segment is actually set up to actually enforce the law. So that's a tough one, Oh my gosh, Rocket Couch, I can't even. Welcome to the long word game where we send micropachycephalosaurus after the losers. That's a dinosaur. Yes, right? Mm-hmm. Micropachycephalosaurus. How's that? Did I say it right? Probably not. Anyway, I'm gonna sign off. Thank you all for listening. I don't know if this one's gonna stay up or not. I'm gonna try to keep it up. That was all 6 of the cases. Thank you for your time. Sorry for the distractions. A little bit of the soapboxing, but it can't be helped sometimes. Yeah, at least I can't help it. I'm human. Anyway, y'all have a great night, and I'll be back during the week.
The only thing we have to fear is fear itself.
Justice requires us to remember when any citizen denies his fellow saying his color is not mine, or his beliefs are strange and different. In that moment, he betrays America.
Be nice and patient and continue to pray. In 100 or 200 years, the problem will work itself out.
I believe that truth is the glue that holds government together. Not only our government, but civilization itself.
In this present crisis, government is not the solution to our problem. Government is the problem.
This nation was founded by men of many nations and backgrounds. It was founded on the principle that all men are created equal, and that the rights of every man are diminished, and the rights of one man are threatened.
America is never wholly herself unless she is engaged in high moral principle. We as a people have such a purpose today. It is to make kinder the face of the nation and gentler the face of the world.
There is nothing wrong with America that cannot be cured by what is right with America.
Through much of the last century, America's faith in freedom and democracy was a rock in a raging sea.
Starting today, we must pick ourselves up, dust ourselves off, and begin again the work of remaking America.